Picture this. You're standing in court, and the judge looks at you and says, "I'm ordering therapy for you and your family." Your stomach drops, your head spins. What now? Welcome to Danny's Den. Let's chat. I once worked with a parent who left that room convinced therapy meant they were about to lose every weekend with their kid. They walked out terrified. It turned out that fear made every message and appointment feel like an audit, and none of that helped the family. Listen, that fear is normal. You're not alone. Here's the short promise. By the time we finish, you'll know why judges ask for therapy, who usually picks the therapist, what privacy looks like, how to keep your parenting time steady, yes, even on big game days, and a quick toolkit to get a reluctant co-parent on board. Also, a tiny playlist to breathe to after a hard session. Not legal advice. Check with your attorney or a licensed therapist for your situation. A lot of the time, a judge isn't trying to punish, right? Mostly they're looking for stability for the kids and practical tools for parents. Judges see patterns like communication that keeps exploding or reunification that's stalled, and they want a path forward that helps the children stay grounded. Who chooses the provider? That varies. Sometimes the order points to a specific program. Other times the court asks for a licensed mental health professional and leaves the choice to the parents with a requirement about credentials. If the judge says the court will pick someone, don't leave that vague. Ask to see the exact wording. When an order shows up, people ask, is this optional? Not always. An order is stronger than a recommendation. Ignoring it can lead to motions, extra hearings, or changes to parenting time. That said, courts usually expect real effort, not perfection. If scheduling is tight because of work or school, raise that early and ask for a reasonable start date rather than missing sessions and risking enforcement. Privacy is where things get tricky. Therapy has protections, but they're not absolute in family cases. Therapists typically won't hand over session notes just because someone asks, but a court can subpoena records, and clinicians may have reporting duties if safety concerns arise. Also, and this is key, court-ordered assessments or custody evaluations are usually written for the court and expected to be shared. Before you start, ask the clinician plainly about reporting. Say something like, "I understand you may have obligations for court referrals. Can you explain what you document and when you would need to share records?" That one line prevents a lot of surprises. If you want to limit what the court sees, ask for narrowly tailored orders. For example, request a report that confirms attendance and participation, not a blow-by-blow of everything discussed. Ask for a limited release that names who gets what and for how long. Those details matter. A little specificity goes a long way. If a therapist suggests a full court report, ask for a draft review, or at minimum, clear expectations about what will be shared. Don't let that surprise knock you sideways. Your attorney can object to overly broad disclosures before the report gets filed. Now, how do you present therapy to kids? Keep it simple and team-focused. We're going to meet with someone who helps families communicate better. Avoid words that sound like blame. For young kids, say, "We want everyone to feel less worried and more calm." For teens, be honest about the purpose and keep expectations realistic. Talking to a co-parent? Start with empathy. "I know this feels invasive, and I don't want you to feel like you're being judged." Then move to outcomes. If we show the court we're trying, it helps keep parenting time stable. Offer a short trial, 3 to 6 sessions, with clear goals and a check-in. Small commitments reduce the fear of forever. Preserve routine. If your household has Eagles or Yankees rituals, protect them. Courts like stability, and kids need predictable anchors. Propose appointment windows that don't clash with key weekends. Offer written swap plans if a session falls on a game day, and keep texts or emails that show the arrangement. Those logs are gold if someone questions your cooperation. A quick micro toolbox. Breathing. Try 4-4-8. Inhale 4, hold 4, exhale 8. Repeat 3 times. Grounding. Name 5 things you see, 4 things you feel, 3 sounds, 2 smells, 1 thing you're thankful for. Use these after tough sessions, before you walk back into family time. And the tiny music moment. Choose low-key R&B or mellow hip-hop to help you come down. Artists with warm, reflective energy, think HER, Leon Bridges, or Sade-like grooves, can give you space to breathe without flipping the emotional switch. Before you go, here's a compact checklist you can act on this week. Ask to see the court's exact language about therapy. Clarify who selects the clinician and what they'll report. Request narrowly tailored releases or reports focused on attendance and measurable milestones. Protect parenting time with written swaps or calendar entries. And if something feels risky, talk to your attorney before signing anything. If this episode helped, subscribe so you don't miss future conversations about law, love, parenting, and sports. If you need case-specific legal help, email Danielle at thelegalassistancecenter.net to book a free 30-minute consultation. You can also drop a comment to share your experiences or questions. Let's chat. Thanks for listening to Danny's Done. Take care of yourself and your family. Small, steady steps usually win in the long run. See you next week.